Oh, that's right. Nope.
Rumor is they're buying you an office cat. Don't move my mic.
It's not a rumor. He's here.
Meow.
So exciting. He's in my office.
I think that's the fourth time today you moved my
I
mic.
did. I'm sorry. The good news is John does not hesitate to tell me what I'm doing wrong.
This is GRL Raw, the podcast where the GRL team tells you why they're different. Who the hell are they? Why should you want them fighting for you? The industry leader in law with over 180 years of combined experience. This team is here to shed light on crucial topics in law to keep you aware and informed, because it comes back to the primary point. We give a damn.
Welcome to hold on. Gotta restart that. Season 2, episode 7. We're titling this one Surviving Slumlords.
Literally surviving slumlords.
Literally surviving slumlords. But we're also tagging this one as our second annual college move-in special.
Because
Do tell.
slumlords.
Prey on college kids.
Yes,
Now, in getting ready, as we always do, did some research.
we did.
You know what the definition of slumlord is?
I do not.
I do.
I figured you would.
Ready? It's a absentee landlord with multiple properties
Yep.
who attempts to maximize profit
Okay.
by minimal maintenance of the property, oftentimes preying on tenants they can intimidate.
Wow. Fits right into our current event, huh?
Current event and college landlords.
Yeah.
And so as everybody's getting ready to pack their kids up, take them to college, move them in to their exciting new apartment,
Yep.
there's some things that we absolutely want to warn people about, and I don't think we could have a more clear, catastrophic example of what happens when people put profit over safety
Yep.
than what we're going to talk about with the Davenport disaster.
Yep.
So why don't we kick it off? What do we got? What is the disaster in Davenport?
The
we're calling it?
disaster in Davenport has made national news, which
As
is
it should.
Yeah, and a sad event for Iowa. But Slumlord in Davenport has a apartment building called the Davenport Hotel, and years of negligence, failures to maintain the building, not a structurally sound building, collapsed with people inside, and it has really brought to everyone's attention the complete failures of Davenport, this slumlord, and the aftermath has also been disastrous, I would say.
It's kind of fascinating in looking at it, the outside and the front. Beautiful old building is
Yeah.
what you
Yeah.
think, but hiding underneath it was
It was
not
literally
even hiding
falling
underneath
apart.
it. I mean, when you get inside it, when you
Yep.
look at everything, doing the research, going through everything. This whole situation was completely avoidable.
It was.
Should never have happened. I look at this as a failure of mankind and
Yeah.
municipal government.
Yep.
It's not some freak accident. Oh my
No.
God, how'd this happen? This is just human morality gone bad.
And one of the hardest parts about our job is always to prove, to show, to allege that someone had noticed. They've
Knowledge.
been warned. They had knowledge. And this is such a clear example of someone that knew exactly what they were doing and blatantly ignored it.
So I'm sure he subscribes to our podcast.
As he should.
But we have to give a shout out to a guy who did a video showing demonstrating a bunch of the failures leading up to the collapse. Guy's
Yep.
name is Jeff Ostroff.
Yep.
We used that video to help get us prepared. I watched half of it and was absolutely appalled.
It is one of the most disgusting set of facts I've ever seen, and we see some things, but this is people's lives, total livelihood are in someone's hands.
So let's burn some people.
Let's do it.
Let's burn some people with this, digging into the current event of the disaster in Davenport.
Yep.
Start with responsible person number 1 as we're looking at this situation.
His name is Andrew Wald.
WOLD.
Yep, not World, Wald.
Wald.
And he is the owner of the Davenport Hotel apartment, has been since 2020.
Okay.
And they've known that this building was not structurally sound since before 2020. But He owns over $11 million of property in the Davenport area.
Multiple properties.
Yep.
Okay.
Yep. Mhm.
Okay.
He fits that check mark.
Check.
Yep.
Okay.
And he, I would say, is going to be primary bad actor in this story.
I think it's scary how much. So he bought the building in 2020.
Yep.
I would assume anytime you buy, not assume, I know when you buy a commercial property,
Yep.
anybody with their right mind has a inspection done.
Yep.
And the inspection then kind of tailors into what you're willing to pay for the building. There's negotiations surrounding that.
Yep.
What we haven't seen yet, with all the information that's been released, is one, was there an inspection done?
Yep.
And then two, what did it have as he's paying millions of dollars, signing his name for millions of dollars to buy this building? What did he know going into it?
And were there any negotiations based on the state of the building for him to save money?
Because that seems to be a theme with these unfortunate cases that we're going to talk to Cory about later on, is that these slumlords go in and buy low, obviously.
Yep.
Their goal is maximize profit, but they buy run-down, dysfunctional buildings
Yep.
at a minimum price, and then put people in them.
Yeah. Families.
Families, kids,
Yeah.
parents,
Yeah.
grandparents. Yep. Okay, so what else do we know about Mr. Wold and his involvement in this?
Well, we know that Mr. Wold, since buying the building, has been cited several times for several different things, including multiple citations for the state of the building.
Who regulates that? Is it the police that hand out citations?
City of Davenport, I think one of the commissions was like some neighborhood commission, but it's the City of Davenport.
Every city has a housing and appeals board, or is what it's
Yep.
called in Des Moines, but they have something that does that function. And so the city knew, I mean, they were in and out of this building doing inspections, writing up
On a regular basis.
citations.
Yes.
Not just warnings,
No,
citations.
also notices to vacate,
What?
multiple notice to vacate
What do you mean?
the apartment by the city
So-
to the apartment.
So before the building fell down,
Yes.
the city of Davenport had provided legal notice to the residents and the owner that this property needed to be vacated, as in nobody lives in this thing.
Because
nobody should live
yep,
in it.
it's because it was years of you need to fix this and years of pushing it off.
And clearly there were people in it.
Yeah.
Not squatters, not people. They were paying rent.
No, they were paying rent.
What was the rent? Do we know what the rent was for like a one bedroom in this place?
Didn't you look it up? Wasn't it like 550 or something?
Yeah.
Yeah.
It's still, listings are still available on apartments.com if somebody wants to look at it.
We might have to screenshot that. And,
yeah.
upload that. Yeah.
$550 a month. So it's not your West Des Moines condo that you would expect. It's a lower rent building. But it had clear, obvious structural integrity issues since August of 2020. And looking at it, I don't know how this guy was granted a rental certificate.
It's unbelievable. It's terrifying.
Yeah.
And since this has happened, he's had they're looking at his other properties now, and multiple other properties are being condemned or notice to vacate for the tenants.
So before we get into what happened with him getting cited for the collapse, because we'll need to move it along. We could spend 2 hours on this, but I found it ironic that in March, before the fall of the collapse of the building, he was cited for like 10, 12, a number of different incidences where he got a citation because his dumpsters were overflowing out of the building.
Just not taking care of the property at all.
Hire
That's
somebody
disgusting.
Hire somebody to take out your trash. Is it that hard?
No.
And then the ironic part of it is when you see the security footage of the building collapse, guess what's still full?
The overflowing garbage.
Yeah. So it wasn't doing anything.
No.
Wasn't doing anything to rectify the situation, which I think is why the city did smack him with a civil infraction right off the bat, right after everything went down. But it's kind of interesting what happened just with a civil citation.
Yeah.
What happened?
So with the civil citation, there were It was a $300 fine ticket citation.
Right.
And
It's
there
less
were,
than a month's rent for one apartment.
Yes. There were talks of some settlement negotiation, and he was trying to take essentially a guilty plea where you don't make an admission of fault.
And the scandalous part of this,
It's not a criminal case.
right?
First of all.
But let's get the scandal out here.
The scandal.
Who's prosecuting this?
The city of Davenport.
Okay. And were they cool with this guy just going? He was trying to do what's called a nolo contender plea, which we don't have in Iowa.
No.
Doesn't exist in Iowa.
No.
That's a different thing. We don't have it.
Yeah.
And was the city cool with that?
The city was cool with that. And they actually went in front of the judge at a hearing and presented to the judge this deal that they had come up with, that he was going to pay the fine but not admit guilt. And the judge said no. And Mr. Andrew Wald, you are going to appear in front of me. Mm-hmm. And I thought that was just wild because...
So at first they tried to do the nolo contender. I can't even say that. The plea without plea.
Yep.
But then they also tried to do a default, which is like a traffic ticket. If you don't show up for certain traffic tickets, they just enter the judgment
Guilty
against
by
you.
default, yep.
You don't plead guilty. So he's playing games trying to avoid taking accountability
Yep.
just for a $300 citation.
And he's doing it for money.
Duh.
Not the $300.
No. He's trying to protect his insurance company.
Yep.
That's going to have to pay out the ass, and probably his another $11 million in assets.
Yeah.
Plus his $2 million mansion he's
Yeah,
building.
because
forgot to
this
mention
lawsuit is like 3 people died. One of the tenants had to have their leg amputated while the rubble on top of them bad. I can't even imagine. Had to be life flighted out of there, but like it wasn't an amputation in a hospital. It was an amputation at the scene.
To save their
Yeah.
life.
And I think it also just shows like that the city of Davenport was going to agree to this.
They were complicit.
They were. And we also have them as, we think, one of the bad actors.
Let's talk about their bad acting.
Yeah. So as the city and the neighborhood commissioner, whoever is issuing the rental certification, has obligations to their people to make sure that there aren't slumlords in their city. And they were an active part in his slumlording.
Because they're the ones that give him legal permission to rent those apartments to people.
Yeah.
So they say, yep, you can put people in these apartments and get paid to do it.
These are safe for them to live in.
We are putting our stamp of approval through this certificate on the safety of this building.
Yep.
And there's inspections associated with getting a rental certificate. If you've ever gone through that process, I know Lindholm rented his house a few times and was mad because he had to change some stairs in his backyard.
That's funny.
But
Yeah.
I mean, they good inspectors get after it.
Yes.
And-
It's important.
Yeah.
Yeah.
And so the guy buys the building in disrepair. They've already been the building was already cited by the city of Davenport before this guy buys it, and then they give him a rental certificate.
Yep.
And then even with the numerous citations, they don't revoke those rental certificates. Let people stay in there. Keep doing inspections. I think there was like August of 2020, November of 2020, July of 2021, November of 2021.
I have a timeline,
Oh,
and
yeah.
this is just from Davenport, like the inspection timeline.
Yeah,
These
tell
are
us.
all like filings,
Okay.
and I mean, it's like 6 pages long. But yeah, we have August 2020. They recommended basically changing the structure or at least adding more support. This is when bricks started falling off the building. There were
This is a problem if you're
massive pieces of cement that were about to fall off. If someone's under that, dead instantly. Then starts back up February 2021, multiple violations. But like inspectors, the city, they were in this apartment building weeks before, like the building was falling down and they all knew it. Literally.
To where right before it fell down, one of the contractors or somebody who had bid on doing some work there actually went to the building and warned the other people that weren't his people.
He told the contractor employees you're going to die if you keep working on this building, get away. Like, I'm giving you your warning. This isn't worth it.
As,
Leave.
as they literally had falling down walls that were propped up with long 2x4s.
Yep. And he knew about the structure of the building because he had bid to the owner $50,000 for all the repair. But
Boy, didn't
Mr.
wanna pay
Andrew
it.
Wald did not want to pay it. So instead, he paid $3,000.
And got a fall down building and a world of shit to go
And
with it.
is going to pay.
Let's talk about that. So, civil lawsuits aside,
Civil lawsuits aside.
when I'm looking at this, I think the guy needs to go to prison.
I do too.
I mean, when you look at how much they knew, if there was a way to make the government agencies responsible as well and send them, give them a taste of prison as well, I think it would be well deserved.
Yeah.
But when we looked at this, I think the only one that could probably legitimately be on the hook, which they are investigating, aren't they?
Yeah. There was a news article yesterday that the DCI is investigating if there's any criminal charges potentially. And
We actually, preparing for this before the DCI news broke, we already had in our head that this dude could get rung up on felony criminal charges.
Yeah.
What? Which ones?
Involuntary manslaughter. And I don't remember. Based on.
I got this.
Okay.
Ready?
Yes.
So there's two types of involuntary manslaughter.
Yep.
One is the just engaging in reckless conduct that results in the death of another person without committing what's called a public offense.
Okay.
So that would be you're not breaking the law, but you're being a reckless dumbass.
Yes.
And somebody gets killed accidentally, but as a result of your reckless conduct.
Yes.
Maybe firearm issues. You know, you're lawfully shooting out at a range, but you're being a dipshit about it.
Yep.
Hit somebody, kill them. That's where that can come into play. That's an aggravated misdemeanor.
Yep.
Not at the felony level. There's no requirement of prison or anything like that. But that one absolutely would fit.
Yes.
But I'm not happy with just a misdemeanor in this case. I think the dude needs a felony. He needs to be a felon, probably a 3-time felon, because there's 3 people that passed away as a result of his bullshit. So there's a Class D felony involuntary manslaughter.
Yep.
Okay. The Class D felony manslaughter or involuntary manslaughter requires the commission of a public offense
Okay.
in a reckless manner.
Yep.
That's where these citations become
Are huge.
They're huge.
Yeah.
They're huge. And the notice to vacate is actually the most important.
Yep.
Because the violation of a building code, a municipal code, actually ends up being a civil infraction,
Yep.
which doesn't qualify as a public offense because you can't get a fine. It's not the same. It's a civil penalty for a municipal infraction, and you can't go to jail. Okay, so we need to somehow make his conduct criminal.
Yep.
Even at the most basic level.
Yep.
And say that it was recklessly committed.
I think they got it.
How?
Well, because of all of the notice to vacates multiple times. There was one February 9th, 2023 is what I was just looking for, that said it was required that the building be vacated by February 27th at midnight. The building was not vacated.
Was there any extensions granted or
There was
any
not
appeals?
any extension granted, but they did. He didn't ask for one, but they ended up giving him another notice to vacate several months later with a different deadline. But
So the notice to vacate is where this is where we get them.
yeah,
So a notice to vacate, a failure to comply with a notice to vacate under the Davenport Municipal Code
yep,
actually can be charged as a simple misdemeanor offense. A simple misdemeanor offense is the basic low-level but criminal offense in Iowa,
Yep.
punishable by up to 30 days in jail and a fine of up to, they keep changing it, I don't even remember what
like
it is.
$300 or something.
Yeah, $325 or $305, $592, I don't know.
Doesn't make any sense.
Look at the website. We got it listed. So if that is the predicate, because their death resulted from his disobedience of the notice to vacate.
Yes,
I bet he still collected checks,
absolutely.
rent checks, during this time.
No doubt.
That qualifies as a public offense.
Yep.
People died as a result of the public offense. That's one count of involuntary manslaughter for each individual that lost their life.
Yep.
that is the bare minimum that should happen in this case.
And I think that I fundamentally don't usually think that someone that doesn't have the actual criminal intent should go to prison around criminals. This is an exception.
Put him in a special cell.
Yeah, I feel good about this man going to prison because devastating effects on a community, families, they're paying $550 in rent. It's a lower income area. This is absolutely disastrous, and he's got blood on his hands.
He's printing money off of tombstones.
Yeah.
I mean, it's that bad.
It is.
He knew what he was doing. Mm-hmm. He's cashing checks while building the rumor is, I don't know if we've confirmed it, but while building like a $2 million mansion out in the Davenport area.
Yep.
All right.
Thanks, Reddit.
Yeah, thanks, Reddit. But before you get to enjoy that, you're going to go spend some time in Iowa Department of Corrections.
And try to at least make these people whole. Yeah. As whole as you can.
I don't think you can in this situation. This is a classic situation also where punitive damages should be allowable against the municipality.
Absolutely.
Because they absolutely had their thumbs up their
asses.
They did. I mean, they're walking around blindfolded because they wanted the tax money.
Yeah.
Think about it. They wanted the income from the $11 million in property. So they're like, oh yeah, go ahead.
Yeah, I mean, and how many other slumlords are there in Davenport that have that much property? Likely not that many, right? He's probably a influential person in that area.
It's disgusting.
Yeah.
But when we come back, we're going to bring in CF Gorley.
We are.
And we're going to tee up GRL's own special case where we got to tee up a landlord, slumlord.
I feel like the plaintiff's attorneys in these cases might be citing that case.
I think they will.
Yeah.
Yeah. So stay tuned. We're going to be right back with some extra juice. Mr. Gorley's coming back. But, hang tight. We'll be right back. We are now live in Season 2 episode. Hold on. This is how this works. Boosh. It's not Bush. 7. Episode 7 of GRL Raw. We are now, I don't know how many total episodes this is in, but we are joined by CF Gorley, Cory, the catastrophic loss expert.
Ooh, that sounds important.
It does, doesn't it?
Yeah.
I came up with that, and I was like, he's going to like that.
Yeah, that's good.
He's going to like that. We are going to talk about, as much as we joke on this podcast, as much as we clown around from time to time, we're going to talk about a serious topic, are we not?
Absolutely.
But before we do, we have had a tradition this year of coming up with the golden quotes, and we try to pull golden quotes that are relevant to the topic that we're going to talk about. And this one is actually perfect. It's plucked right out of a case that you handled, that you did. And we always make, the featured attorney or the featured guest give the quote. And you have the quote, I have the quote here, but I'm going to set the scene. And the scene is that there is a property owner who has been brought before the Housing and Appeals Board, Des Moines Housing and Appeals Board, for numerous violations of the housing code. Owns rental property, is supposed to be bringing the rental property up to code, came in and actually tried to, they make it out to like they're saving distressed property, but what it is they call that a deal in the business world. They came in low and they're trying to build it up and sell it high, get as much time as they can.
They came in low to make money, and then the city said, oh, by the way, you need to fix this
FYI,
big pile of garbage. Yeah.
Which is going to be a theme with this episode is FYI, you bought this on the cheap, but there's a reason. It's because it's a death trap.
Yeah, now fix it.
And what happened is this quote happens right after somebody from the Housing and Appeals Board, this is all recorded, this is transcribed, typed out by a court reporter, informs the new owner that this is a health and safety issue. If you don't fix this puts the residents in danger. And in particular, what we're talking about is balcony railing levels. It was the railings that they had on the balconies of this specific apartment complex were too short. And when after the Housing Appeals Board gets done telling them this is a health and safety issue, this is a matter of life and death, the dude says what?
One of their excuses, their primary excuse, was that it's not as if someone has fallen off yet.
That I know of.
Yeah.
So they're told, listen, these balcony railings are too short. You need to fix them. And their response is they have not had anybody fall off.
And it was also interesting, one of the immediate responses by one of the members of the Housing Appeals Board was, listen, I don't want my name associated with somebody's kid who falls over that railing and dies. And they
You're
said,
right,
okay,
that was part
yeah,
of it.
Yeah.
And that's perfect segue. Unfortunately, to the case that we're going to lead into, we've made it a habit of talking about some historic cases. This is a different case. It's not one that goes way back into antiquity. It's not printed in the Northwest First.
I don't think everybody knows what the
They don't
Northwest
know that
First
is
is,
at
but
all.
yeah, okay.
That was a bad analogy. But this isn't on parchment paper.
There you go.
There we go.
A few people might know
This
what
is a recent case, and it's actually a case that we were involved with. You primarily handled from start to finish, where a landlord was sued for not keeping the property up to code and resulting in a tragic preventable death of a young lady that was a guest at the apartment complex.
Yeah, and might it help to give a little background as to how we got the case and how we began investigating it?
Yeah.
So we got a call from some folks that I knew who had some friends whose daughter had fallen off of a balcony and passed away as a result of that fall. And the only thing we knew initially was that she was at a friend's house. They were college age. She was 21 at the time. They had been out drinking, and they came back to the apartment and drank some more, watched a movie. There were also allegations of having marijuana in her system as well as Xanax in her system. Basically, a young gal may have been inebriated, fell off this balcony and passed away. And
Nobody sitting at this table has ever been in that condition ever before.
yes, not once,
At all.
not even accused of doing anything like that.
No
But,
such thing. Yeah.
But so you receive something like that, and you're like, okay. I mean, they're basically saying, and this is what the defense argued, was that a drunk high girl falls off a balcony and it's our fault. Get out of here. But as we, I guess, are known for doing, we said, well, maybe there's more to this story. So we started looking into it, and initially we find out, wait. The balcony that she fell over was 10 inches too low. It was 32 inches, and the Uniform Building Code at that time, or even now, is
Currently, yeah.
42 inches. And then we dug further and found out, not only is that the case, they had been warned about this and cited about it over and over and over again beforehand. So that kind of sets the stage for the entire case.
And it sets the stage for the entire case, but it also brings this topic to relevance for college-age kids' parents. And like, we always try to make this relevant to anybody. Last year at College Move-In, we did a special with the Wolf on, how not to get rung up on certain things,
Yep.
certain accusations. And we want to make that, a lot of times I think people look at the we'll, just for lack of a better description, we'll call it the slumlord issue, where people buy property that is distressed. They rent it out as much as they can for as often as they can, make as much money without doing any of the improvements that they can. They look at it as a socioeconomic kind of problem, right? People without the money, you get what you can get. But we found, in our experience, and from cases that we've had, is that a lot of the victims of these types of landlord negligence cases directly impact college kids.
Yeah, you think if you rent an apartment or, you rent a hotel or a motel room you should have a reasonable expectation that place is going to be basically safe. There aren't going to be any latent defects or hazards that are there that they're not going to tell you about, or that should exist at all. And that's especially relevant, I think, for parents because, I don't know, maybe many of us as adults are in a place and we think, all right, well, we're, relatively responsible. We think we're going to notice if something's wrong. We all worry about our kids. We all, especially college-age kids who aren't always paying attention. You well know.
Let me tell you.
As a parent of a college-age kid, but they're not always paying as close of attention as they should be. And when we're sending our kids to places to live, to hang out, to reside, we have an expectation, a reasonable expectation. Those kids should be safe.
Well, and there's the tragic reality, quite frankly, is that I think the college-age students, the kids that are moving into new places, they're excited. Listen, you don't have to have a swank apartment as a college kid to have fun.
Everything's new and cool when you're that age.
It's awesome.
Yep.
You don't have parents telling you what to do, when to do anything. And so you're going to do whatever you think you have to do to get by. And you're going to be in some housing. And the people that sometimes, unfortunately, the people that own that housing that are making money and profits off that housing are going to cut corners that impact safety. And college-age kids aren't going to be in a position to stand up and say, hey, no, my railing is too short, or there's a hole in my railing, or the outside of this building is about to collapse. Like there's a lot of things that need to be done here. All they care about is getting to class, well, not even that, but doing all the other fun stuff associated with college. And the other things, they get bullied. They get, the landlord's like, no, this is what has to happen. We're going to take care of it, but they never do.
Yeah, as a young person, number one, like we talked about, they may not even recognize the issues that are involved. Mm-hmm. And two, even if they do, as we may talk about a little later on a current case we're working on, they may say, hey, landlord, we've got a problem here. And the landlord says, what are you going to do about it? And as a college student, or a young adult, you say, I guess I can't do anything about it. You don't know what your leverage is. You don't know what your recourse is. And unfortunately, some landlords take advantage of that.
Yeah, what are you going to do? Tell your daddy about it?
Yeah.
Right. And they're just going to play that card to try to make the kid, tolerate some things. But so this case, it was a Des Moines case. It was, unfortunately, literally right across the street from Des Moines University. Yeah. They're in the process of moving, but the address was 3103 Grand Avenue, right downtown. The defendant was CM Holdings. One of the named individual defendants was Mark Critelli, I believe was the guy's name, who made himself quite a name with the Register, slumlord accusations, a lot of problems with the properties that he had. So kind of walk us through then how the case came about. I mean, you talked about how we dug into it, what happened with it, but walk us through a little bit of it.
Yeah, so, you go from a case that sounds like, well, there's probably not going to be much there. You're just walking the family through the situation, you investigate a little bit, find out some of these initial factors, and you're like, well, now wait a minute, there really may be something here, and we continued to dig in. We also often say there's never a smoking gun. Well, when you say it's not like somebody's fallen off and died yet, it's pretty close to a smoking gun. But so anyway, as we began investigating this case, it got worse and worse for Mr. Critelli and his holdings company, and better for our case. So we look into was there anything wrong? We found out there was.
The railings were too low.
The railings were too low. So then the next question was, causation. And we had to determine, okay, well, even though they're too low, does that 10 inches really make a difference? And
this was the most fascinating part of this case for me.
It was. So we hired an extraordinarily gifted biomechanical engineer out of Arizona State University who was experienced with bodies in motion through space. And he got that experience through working with Olympic divers and trying to minimize their surface contact as they entered the water and how their bodies fell through
It was a science
space.
to move
Yeah.
through space. And,
Yep.
Okay.
And so he was the perfect person to help us determine how she fell, how she ended up in the position she was in, which was on her back, and then B, why she fell. And so the doctor from Arizona State and I created a recreation with a model body double who was a similar size of our deceased client, and we actually did tests.
They did multiple film tests of the railing difference, right?
Yep, and so we had the model fall backwards and be drawn backwards on a hydraulic platform at different speeds with the 32-inch railing as it was and the 42-inch railing. And the interesting thing about that was if they barely bumped into the 32-inch railing, sometimes they didn't fall, or sometimes she didn't fall. If she had enough speed and momentum, she fell over, and then she fell into a pad. There's a pad behind her. But the 42-inch railing stopped the fall every single time. And as we researched it further, we determined that 42 inches is above the center of gravity for most American citizens of average and a little bit above average height.
So, for the record, the building code at the time of the fall required railings, and as of today, I believe, requires railings to be 42 inches high if you're so far off the ground.
Because that is above the center of gravity for the majority of the population. Yep.
And this particular apartment complex had railings at 32 inches, which was 10 inches shorter. Did math, Sydney, sitting over there in the corner. 10 inches shorter. And the difference is, the reason for that is 42 inches is above the center of gravity, which keeps you in, as opposed to 32 inches, which actually, when you hit it, does what?
Well, and I'm actually similar height to the gal. I don't know if you can see it, but you, it's the difference between a railing coming up to your back and stopping you here at 42 inches, or the railing coming to your legs at 32 inches and basically cutting your legs out from under you. It is a difference between
under your butt and over your butt.
Yeah, a tripping you or protecting you.
Yeah.
That 10 inches makes all the difference in the world.
And God, science is fantastic. But the amazing part of it is the code, the building code. So every city has a building code, correct?
Yeah, there's a uniform building code, which is generally adopted with small modifications from every municipality in the country, mostly.
And so we have the International Building Code, as that's called.
Yep.
And most of the cities have adopted the International Building Code and said, this is what we're using.
In some form or fashion, yeah.
In some form or fashion, with small alterations for the small, or the peculiar needs of the municipality.
Yep.
And so in this particular case, railings were 32 inches, supposed to be 42 inches. What was their excuse? Like how did, every time, clearly this case went to trial, right?
It did.
Whomped them at trial, but they got an excuse that they're going to try to play off of. What was the excuse they were trying to play off of?
Well, so they tried to use a lot of different defenses, and it just kept getting worse for them. So after we found out that, they had violated the code, the causation was there. Then it was, did they know about it? They did. They've been notified time and again through both written notifications, conversations with the city inspector, as well as hearings. And then they said, oh, well, we're grandfathered in because, which was one of their first excuses, because the old code allowed us to have it at 32 inches, which is true unless certain conditions
So
happen.
what's this whole grandfather clause? That doesn't seem like, if it's to protect life and liberty and safety, like how is there such thing as a grandfather clause? We're grandfathering in, you can kill people.
So there's a balance. Over time, as building codes change, they may develop new standards and say, you know what, 42 inches is safer than 32 inches. However, that has to be balanced with, okay, well, now can you automatically go out and compel every single building owner to immediately change it to meet that code? And that has been thought to be overly burdensome initially. And so they say, okay, well, there are certain triggering events. it's so long as you comply with the code as it was written at the time that the building was built, generally you're in compliance, and that's called grandfathering in, even once the code changes. However, there are certain triggering events that can occur that then say, okay, this occurred, now you have to bring it up.
So what
to
requires
standard.
them to bring it up to current standards?
Sometimes it can be change of ownership, things like that, but in this particular instance, it was a modification to the railing itself. If you modify what is already not otherwise compliant with code, then you have to bring it up to code.
These were steel railings on a balcony on an old building. How in the hell were these railings modified in any way?
These particular defendants chose the absolute worst of all worlds. Instead of just leaving it as it was until they fixed it, or moving people out until it was fixed.
That's an option, right?
For sure, yeah.
Give people safe places to live.
And they moved some people out of some buildings, but not everybody out of all their buildings because, they didn't want to lose that money
dollar.
coming in. And so, or instead of, immediately replacing all of those railings, because these really they were charged when they initially took possession of this building and bought it, and the initial inspection found 106 violations at this building. Some of them impacted health and safety. Some of them did not immediately impact health and safety. They were, lesser issues. This was the most serious issue. They fixed everything else first and this last.
The cheapest ones they fixed first.
That's right, and saved the worst for last. So what they did was, instead of fixing it first or moving people out or warning them that this is an issue, doing anything like that, they nailed a flimsy plastic lattice around and on top of the railing to extend it almost to the height of the next floor. And so what that did was gave a false sense of security.
Hold on, lattice. What are we talking about with lattice? Like, help me understand plastic lattice.
Just pieces of plastic that are
Crisscross
crisscrossed,
applesauce.
and almost create a fence.
So it's that stuff that you would, like, if you have string beans, you want your beans to climb up something, or your tomatoes, gardening. I know you do a lot of gardening. But like it's that stuff that you let vines crawl up, right? In gardens?
Yeah, I'd say more like vines. The actual metal cages that are around tomatoes.
Yeah, not
those are different.
The crisscross white things that are flimsy as hell that you put up to let vines grow.
They are merely decorative in nature. That's all they're used for. So if you have some little garden and you want to put some cute little white fence that serves no purpose other than maybe you keep, rabbits out or something. I mean, they serve no significant barrier other than mainly decoration.
Okay.
Yeah.
And so they strap those to the outside of the railings?
The outside of the railings to extend the railings up another 4 to 5 feet. So now when you walk out on this deck with a railing that's already too low and dangerous, you no longer just see, there's a railing there, and perceive its height. You see, I'm actually enclosed completely around it. And so your perception from walking out there was that you're secure, you're enclosed in there, no need to worry there.
So the psychiatric effect and the physiological effect is I'm safe because I have much more protection that goes up. Whereas, for example, if you walk out on a deck or a patio that doesn't have any railings, you stay way back. You're not going to tiptoe to the edge. If you do, you're going to army crawl.
And I'm timid around heights. And so, especially if there's something low and the higher it is, I'm like staying away from that. But if I'm enclosed and there's, glass or something, no problem. I'll go right up to the edge, which is exactly what this was. It was the worst of all worlds.
It was the worst of all worlds, and I think it was most demonstrated. You had an investigator go out and take pictures shortly after the event, which is one of the important takeaways from the case is get people involved right away, because a lot of these things need to be documented if they're not documented, right?
Well, absolutely. And over time, these cases can take such a long time, especially like this one, which was appealed after we won it, and then appealed again after that. Evidence goes away, and things are changed, and people move, and access is difficult. And so it would have been difficult, if not impossible, for our expert in Arizona to come to his opinion if he didn't have a depiction of the site, and not just the site in general, but the site in the exact same condition as it was at the time of the fall.
Because ultimately, we got pictures of the lattice are still attached
Yeah.
to the balconies, and that showed the false sense of security that it would give to people.
Yeah, and pretty much all of the professionals, whether it be the city inspector, our expert, they to a man, they were, you got to be kidding me. They put this around it. I mean, do nothing. You know,
That's
you know,
not
if you're
holding
not going to
anybody
fix it, do nothing. Don't make it look like or feel like people are safe when they're not.
You can print off a warning that says, "Hey, don't."
Yeah,
run
this
about."
is too low. Yeah.
So how did that case turn out? Like, so on the initial level, we get it, you work it up, get all this extra information, get the owner saying things.
Yeah, so this was a unique case because when we go to trial, we have to prove three things. We have to prove who's responsible, which is called liability, and why they're responsible, what they did wrong, what was negligent. We have to prove causation, which is that their negligence caused something bad to happen, and then what those damages are, what bad things happened, what injuries. In this case, it was death and the loss of a relationship with a daughter. So one of the other unique factors about this case was that when it came to liability, we actually filed a motion before trial asking that the court determine liability, take it away from the jury and just say, nope, they're responsible because they violated the law.
Which they did.
That's called negligence per se.
Yep.
In Iowa, at that time, before this case, there was some question whether or not the negligence per se could be based upon municipal ordinances in addition to statewide laws.
So, for example, running a stoplight, hitting somebody is what's called negligence per se, or in other words, negligence, you're screwed.
Because it's a violation of the Iowa Code. Somewhere in Iowa Code section 321, it says, don't run stop signs.
Right.
Yeah.
And so the question is whether or not don't have your property in non-compliance with the building code is the same thing as don't run stop signs.
Yeah.
Okay. And so how did that, what happened with that?
So the judge initially, when we filed the motion and said, it's called a motion for summary judgment. Typically, they're filed by the defense to get a case thrown out. We filed it offensively and said, we don't think we should even have to deal with liability. That should be already just deemed proven by the court as a matter of law, is what it's called. All we should talk about is damages and causation. And the judge said, I'm too busy to rule on it. That's what happened. He said, do you have any idea how busy I am? I'm too busy. I'm not ruling on it. So we proceeded to go try the case and had to try liability. It was interesting because it seemed less than judicially efficient to have to try that with as strong as a position as we had on that. But nonetheless, we tried the case and put on our evidence.
And?
Yeah, so then at the close of evidence, both us and the defense moved for what's called directed verdict at that time, saying we should win based on the evidence at that time. And the judge then said, yep, you're right, you win. And so instead of granting it before trial and saving all that time on that part of the case, the judge just let us put all the evidence on and said, yeah, I agree with your previous motion. You win as a matter of law, and the jury doesn't decide that. The jury just gets to decide, did the defendant's action cause Shannon's death, and then what are the damages?
And they did.
They did,
found
yeah.
it.
They
Whomped them.
Yeah, I believe that was 2015 or 2016, and that was one of, if not the highest jury verdicts of that year.
1.75 or something like that.
Yeah, it was
big.
1.75 million. It was just under, so I think $875,000 per parent for their loss of their relationship with their daughter. It was reduced by what's called comparative fault because the jury put some fault on Shannon for not keeping her balance. We argued that rails only exist for when people don't have their balance.
That's the point
for
of
any
them.
reason, whether you're running from a bee or you trip on a nail or you drank legally at your friend's home, like where you're supposed to drink, you were not driving around.
Right.
It doesn't really matter why you fall, but they put some fault on her, 35%, so it was reduced to just under 1.2 million was the ultimate verdict.
And then the whole show went up on appeal.
Well, first of all, it went to the judge. They filed post-trial motions asking for them to throw
that's
out the
right.
verdict.
Yep.
And They always do that, and it never wins, or it never, the judge never does that, except in this case. The judge overruled himself and said, no, I changed my mind. I shouldn't have given you directed verdict on liability. So I'm going to throw out my own ruling, overrule it. I'm going to overrule my own ruling, throw out the verdict, and we're going to go do it again.
And then it went out.
Then we appealed.
And then both sides appealed.
And so did they.
There was an appeal, cross appeal. No, I see your raise, I raise you back.
Yep.
But ultimately, it went through the Court of Appeals, and then ultimately the Iowa Supreme Court ruled on this case.
It was interesting because typically, and you're one of our appellate masters here and helped out with.
I'm retired.
So anybody that wants to file an appeal always call.
I retired.
Bobby.
I'm done.
But no, you worked a lot on this appeal, and typically what happens is you appeal to the Iowa Supreme Court and they say, Court of Appeals, you handle it. And the Court of Appeals handled it, and that's typically a 3-judge panel. And in this case, all 3 judges had different opinions.
Yeah, they did. It was split.
It was very interesting, and they all wrote separate opinions, which very rarely occurs. And so then the Supreme Court said, well, we may need to address this. If our 3 appellate court judges can't even agree, and the district court judge can't even agree with himself, might be something we need to take a look at.
Right.
Yeah. So.
And then the Iowa Supreme Court took it up. We argued that it was a Drake Legal Clinic.
That's right. Yeah, that's right. Yeah.
It was a Drake Legal Clinic, and
law students got to see it.
Yep, 2016. I think the ruling finally came down. And one of the important takeaways of this case that we talk about positive impact, and we talked about the last time you were on the podcast, is when you make arguments, when you force the hand of the bad actors, you have the ability to set precedent for other people. And there's a big positive impact that this case had by going all that way, which was what?
Well, I would back up just a little bit and say there were 3 big takeaways, I think, from this case. Number one, what we pride ourselves on, I would suggest that 90% of law firms wouldn't have looked at this far enough and in detail enough to discover, hey, there's more to it than a drunk 21-year-old gal fell off a balcony.
Right.
And so I think, that goes to show that the investigation that we do, the extra time and effort we put into really digging into our cases matters. The second part was we ended up winning the case. The appeal process was attenuated, but ultimately it all worked out, and justice was achieved for our clients. But the third thing was, and every bit as important as the first 2, if not more, was that we changed the law in Iowa.
Right.
There was a really bad case called Griglione that was out there.
I remember that.
And
case.
it was, and you're the one that found that they relied upon what we called dicta in a previous case. And
DICTA.
Yeah, which means something that a appellate court says that doesn't have the value of precedence.
Right, not coach.
Yeah,
not the coach.
It's not authority. It doesn't mean anything. It's just kind of other verbiage. But anyway, they had improperly relied on a previous case and came to a ruling that said if it's not a state law or not a law that applies statewide, then it can't form the basis of negligence per se, which made no sense. Because
Right.
if you violate the law,
You violated the law.
yeah, and if the law is the law in Des Moines or Davenport or wherever a building is deficient, it should apply. And because of that case and our win and your work on that appeal, the Supreme Court didn't just rule in our favor. They overruled that bad case and said, you're right, the law's bad, we're changing it. And now, because of that case, from here on out, every code, municipal or otherwise, can form the basis of negligence per se if you violate it and it applies to that situation.
And the important takeaway is if a landlord violates a building code or housing ordinance that adversely impacts a person that lives there, they don't get to say, "Ooh, no, that's not the real law."
Well, and I'm a common sense guy. And why do we have building codes? We have building codes to keep people safe. And if they violate them, there should be recourse for that.
Right.
Seems pretty simple to me. And the Supreme Court got to the right decision on
They
that
did.
one. Yep.
So
Absolutely.
we always give action points. So we have families moving college kids in again, as this is getting broadcasted, and we need to give them some action points, ways to protect their kids, ways to ensure their kids are protected, so that the place they sleep is not going to be their worst nightmare.
Yeah.
What are some of those action points?
Well, first of all, once again, common sense drives a lot of this. But if there's a defect, and there can be defects in properties that are 80 years old or 8 months old. We've got a new case currently that we're working on where a very new building was just missing part of the railings on a deck, and another kid fell through that. And
We call college kids these days because
Yeah.
we're getting old.
yeah. But if you find something that's dangerous or hazardous, look around, pay attention, and stay on the landlord. They are required by law to fix those issues, and they may be slow, they may be non-responsive. Sometimes they have bad managers, but stay on them because they are required to fix them. So I'd say that's the very first thing is.
Report deficiencies.
Yeah, absolutely.
In writing.
Look, find them, report them in writing, memorialize them, and save them. However they have you do that. Fill something out, take it, just copy it, or send an email, save the email, whatever it is.
And I'll go one step a little bit back is require rental certificates. I mean, unless it's like a daycare. You're not going to trust your kid to somebody who isn't licensed unless you know for a fact you can trust them with their life.
And that there's a licensing requirement that only kicks in after so many children.
Correct.
Yeah.
But you know what I mean?
Yep.
Like it's the same concept. Either I know you and I can trust you with my kids, or you're going to prove to me that you've proved to the state that you were worthy of taking care of this.
And that's a good delineation that you make, because sometimes you're renting an apartment or a condo or whatever it is, and those are almost always going to be subject to city inspectors.
Right.
If you're renting a house or what is otherwise just a residence, that cannot be rented under Iowa law unless there's a rental certificate, and the state or the city may not know about that. The municipality may not know that it's being rented unless there's a rental certificate. And so with a condo or an apartment, you can be relatively safe that it's been inspected. Doesn't mean it's always safe, but with a house, that's a whole new, different type of things. And college kids rent houses. I mean, they
bifurcate houses. They break houses down into 8 different apartments.
and they're oftentimes not safe for ingress and egress, for fires, for fire suppression if necessary. But there have to be rental certificates, because those will say the municipality came out, looked at it, certified that there aren't any obvious problems, and you can be assured of at least some level of safety.
And that would follow up that the other situation is take inspection seriously.
Absolutely.
Look for things like balconies, railings, stairs, handrails, wiring, smoke detectors, fire escapes, ventilation, all
Carbon
that
monoxide.
Yeah.
Whatever those monitors that you plug in.
And I'm gonna leave with this because we're running out of time.
Okay.
But I think it's important that instead of getting wrapped up into Mom and Dad, I'm good, just leave me alone, get away. By the way, that's what kids do when they go to college.
You'd know.
I know.
Yep.
I got this, right? Safety first. And when there is a doubt about the safety of a residence, get the fuck out. Like, you're not gonna don't put your kids. They should not be in danger where they sleep.
Use your common sense and follow your gut. If it doesn't seem right, if they're it's fine. If they're not taking safety issues seriously, use your gut, get out, and also look at your kids' spots. Make sure you check it out. You see where they're sleeping. You see where they're at. If you don't think it's safe or reasonable, there's a reason for that.
And you can search for complaints. You can search within the city. You can ask the city and follow up with that. There's other alternatives that are available, but be proactive, be careful, be safe, and understand that where you sleep matters.
Yeah.
Yeah. Appreciate you taking the time. We're out of time.
Absolutely.
You did a great job. We learned a lot about an important. I think it flies under the radar. It really does, but it's something that I think every parent sending their kids off to college needs to take heed and pay attention to.
You think that you can expect your residence, your apartment, your condos to be safe, and most of the time that's probably true, but not always. So use your common sense, check it out, and if there's something you question it, and stay after it.
Don't take chances.
Yep.
Appreciate it, boss.
Yep. Cheers.
As always, cheers.
Yep.
I finally touched this whiskey.
Hello,
What's up?
We're back.
We're back, and we have I'm told, just a straight
Law school essay.
essay, do's and don'ts with Dognut.
It is premise liability themed, so that is what we're going with.
Look at us matching up what we're
I
talking
know.
about. We have our
Good
current
planning.
event, the substantive discussion, and now do's and don'ts all are going to work together.
They do.
Roll with it.
Perfect. All right, title. 2 15-year-olds jumped my brother's fence to try to steal stuff out of his backyard. One of them got severe injuries from my brother's pit bull. Any advice? My brother has 2 four-wheelers in his backyard. Around 1 a.m. this morning, he heard screams and his dog barking. He went to see, and the dog had attacked one of the boys. He tore his leg, ankle up pretty bad. To sum things up, my brother has these 2 kids on his camera jumping the fence, trying to steal the four-wheelers. His pit bull was outside in his doghouse. One kid saw the dog and tried to throw something at it, and the dog charged him. The guy who got bit, his mom, came to my brother's house and wants to sue. Who is at fault?
How old are kids?
15.
You know, this actually kind of weaves in with our prior discussion with the wolf on justification.
Yep.
Defensive property.
Yep.
Well, I'm going to go with the obvious.
Okay.
First of all, what do you think?
I have 2 immediate do's and 2 immediate don'ts right off the bat.
Throw them out there.
1, report any criminal activity immediately. The brother.
The homeowner.
The homeowner
100%.
has to call the police, file a report, give them the video.
Yep.
That's
100%.
step 1. If you haven't already done that, you needed to do it that morning.
Yep.
2, contact your insurance providers and also provide them the information and the video, because this is potentially going to be a lawsuit. So you got to go on the defense a little bit.
Correct.
Immediate don'ts: don't talk to that mom. Cut her off.
Yep.
Second one: don't make any admissions and don't apologize. Those are my first off the bat thoughts.
I'm going with you're fine. I'm going with homeowners fine.
Yeah.
Stupid kids get what stupid kids get.
Okay.
Don't try to steal stuff. And don't. You're in an enclosed area and you're gonna chuck something at a pit bull.
Yeah.
You deserve to get your ass beat
Yep.
and bit.
A lot of people would think the trespassing part is going to be the determining factor.
But this is law.
Children have special obligations under the law, and technically they're never really trespassers in the sense that children aren't required to make logical decisions to know that you're on someone else's land.
What about you jump a fence?
Well, so there's something called the attractive nuisance
Okay.
doctrine in torts.
Yep, I remember
and
Torch Daddy talking
it
about this.
Essentially is if you have some artificial machinery or something that would attract children on your property, you have a special obligation to protect children from your land.
Wouldn't a fence do that?
What?
Wouldn't a fence be considered?
Maybe.
I'm on property.
Were the keys in the four-wheelers? Had the kids been able to drive the four-wheelers before?
No, we need more. That's
did they have
additional
access?
facts.
Uh-huh.
How big is the fence? How tall is the fence?
How tall is the fence? Did they know there was a pit bull there?
Whether they chucked a shoe at it.
Yeah, well, they found out after they jumped the fence.
Well, and I guess that's one of the reasons why cities require that pools be surrounded by, I believe,
Yep.
at least a 6-foot fence.
Yep.
So if it's a little chain link fence, I'm still on team landowners, firmly on their side, 100% on their side.
I agree.
I would say do give your pit bull an extra biscuit. But no, so the other thing comes down also, let's think about this, is how often do kids go through the yard,
Yep.
jump the fence?
Does your dog have a history of attack?
Here's my concern for the landlord. It's not criminal liability at all. It's dog bite liability.
Yep.
Because in Iowa and in a lot of states, a owner is strictly liable for damages caused when their animal attacks somebody. Do you know?
Yeah, if they're involved in criminal activity or trespassing, but
Is that a defense?
yes,
Okay.
but children can't necessarily be trespassers. And how do you show they're trying to steal your ATV?
Well, you ask them.
Attempted theft?
Well, you ask them.
Yeah.
What are you doing?
Yeah.
Why were you in the backyard?
Yep.
That-
I mean,
but that's-
end of the day, that's like outside looking in. What else are you doing there?
Right. I think that's where it goes to your due call law enforcement right away.
Immediately.
Because then they can engage in their investigation, find out what the kids were doing, why
Yep.
they were there. 15-year-old, they're not going to get a criminal charge as a result of it, more than likely. I mean, trespass? There's no such thing as attempted theft.
Exactly.
At least in Iowa, we
Yeah.
don't have attempted theft.
Yep.
So I like that advice right off the bat. Do call law enforcement. Do report it. Do save your video.
Yes.
Because that video can
Multiple
save your ass.
copies. One of them in a safe at a bank, maybe. Like
100%, because that's going to be your
Yeah.
homeowner's insurance policy for the next 20 years.
yes.
But kids, don't jump fences when dogs
No.
are there.
No.
It could be a cute little wiener schnitzel or a Dutch hound.
Yeah, you never know.
Some of the meanest
And you
dogs are the
also
small
never-
dogs.
Last episode, you never know when you're gonna run up on a crazy person. Don't
Don't trespass.
Just don't trespass. Don't trespass. Don't try to steal people's things, especially if there's a pit bull, German Shepherd, any other dog. My dog would probably bite someone if they jumped over a fence.
Yep.
Definitely if they threw something at him.
Yeah.
But
Don't
as he should.
throw things at dogs.
No.
We can end on that.
Yeah.
Cheers.
We can't change the past, but we will change your future. GRL Law. Thanks for tuning in to GRL Raw. Check us out at grllaw.com.